Hello, my name is Soumya Uma. I work as Assistant Professor of Law in Maharashtra National Law University, Mumbai. My work has been around the issue of human rights and the law, including child rights. I'm here to discuss with all of you 4 modules on juvenile justice system. So let's start with the first module. The first module is on evolution of juvenile justice system in India, part 1. Let's see what the learning objectives of this module are. Firstly, it is to understand what is juvenile justice and what is the system of juvenile justice administration. Secondly, to develop insights into the need for a separate juvenile justice system. Thirdly, to have an overview of the fundamental concepts and varied approaches to juvenile justice. And fourthly, to understand the historical evolution of the law on juvenile justice in India. The structure of the module will be firstly introduction, then who is a juvenile, what is juvenile delinquency, fourthly, need for a separate system of criminal justice for juveniles, fifthly, approaches to juvenile justice, sixthly, punishment versus rehabilitation, and seventhly, evolution of juvenile justice law in India. So let's start with understanding what do we mean by juvenile justice. Juvenile justice is a system of law that is intended to protect and to promote the human rights of all young people. It is a branch of law that deals with minor or underaged persons who have been accused of offences or who are neglected or abandoned by their parents or guardians. The fact is that it is more concerned with the rehabilitation of its charges than adult criminal justice. In the context of juveniles who are accused of offences, which is termed in law as juveniles in conflict with the law, there are international standards that exist, and these standards emphasize the importance of both prevention as well as rehabilitation. International standards recognize that the right of every child alleged as, accused of, or recognized as having infringed the penal law is to be treated in a manner that is consistent with the promotion of the child's sense of dignity and worth. Juvenile justice policy in India is largely governed by the constitutional mandate given under Article 15 that guarantees special attention to children, special protection of children through necessary and special laws and policies that safeguard their rights. This policy is also founded on the constitutional guarantees such as the right to equality, protection of life and personal liberty, and the right against exploitation. These are all fundamental rights which are enshrined in Articles 14, 15, 16, 21, 23 and 24 of the Indian Constitution. The Indian Constitution emphasizes on the duty of the state to prevent exploitation of children and to promote children's welfare. So the juvenile justice policy in India is not only based on the Constitution but also influenced by international standards and jurisprudence. These will be discussed much more elaborately in modules 3 and 4. The present law, which is the Juvenile Justice, Care and Protection of Children Act, this was enacted in 2000, amended in 2006, and then it was replaced in 2015 by a new law, which is Juvenile Justice, Care and Protection of Children Act 2015. So we will be discussing all of these laws in this and the next module. So let's try and understand as to who is a juvenile. A juvenile can be defined as a child who has not attained a certain age at which, like an adult, under the law of the land can be held liable for his or her criminal acts. The term juvenile justice emerged from the Latin word juvenis. Juvenis means young. Hence, a juvenile justice system is one that is specially established for the young. As per the Juvenile Justice, Care and Protection of Children Act 2015, the term juvenile refers to a child below the age of 18 years. The 2015 Act deals with two kinds of children. One, children in conflict with the law, defined as a child who has alleged or found to have committed an offence and who has not completed 18 years of age on the date of commission of the offence. The second category that the Juvenile Justice Act deals with is a child in need of care and protection, which includes many situations where children are abused, exploited, neglected or inflicted violence upon without being cared for by their parent or guardian. Now let's try and understand as to what is juvenile delinquency. This is a term which is used very often. Juvenile delinquents are those who have not attained the age of adulthood as per the law of the land, and yet they have acted in a manner that is prohibited by the law. Such kind of prohibited behavior largely consists of acts which would be termed as offences under the criminal law when those particular acts are committed by adults. Since the child is a part of society, social context around him or her is bound to have an effect on the child's attitude and behavior. Poverty, unemployment, exposure to and experience of violence, abuse, inequalities and changing values are bound to impact children and their behavior. There is a complex mix of social, economic and human factors that contribute to juvenile delinquency. Risk factors contributing to juvenile delinquency may be categorized as follows. Number 1, individual risk. Number 2, family risk. Number 3, mental health risk. And number 4, substance abuse risk. Individual risk factors are those pertaining to the juvenile as an individual, including his or her physical, mental and emotional self. Family risk factors are those factors pertaining to parents and other family members who are responsible for the upbringing of the juvenile. They include upbringing by the relatives in the absence of parents who may not have emotional attachment towards the child, or they may not be able to provide proper attention to the needs of the juvenile. Thirdly, mental health risk factors. What are these? These are factors which are precursors of certain mental health conditions that tend to be displayed through juvenile delinquent behavior. Fourthly, substance abuse risk factors. These are those risk factors pertaining to access to and abuse of drugs and other forms of illegal substances. In your notes, you will look at matrix 1, which further illustrates various risks and causative factors for juvenile delinquency. It is pertinent to note that the Juvenile Justice Act 2000 does not use the term juvenile delinquency, but it uses the term child in conflict with the law. If you look back at matrix 1, which are the causative factors for juvenile delinquency, you will understand better some of these issues. The National Crime Records Bureau statistics indicate that while the cases registered against juveniles in conflict with the law has seen a steady increase in the last decade, the share of Indian Penal Code crimes registered against juveniles to the total Indian Penal Code crimes registered in the country during 2005 was only 1%, and in 2015 this has marginally increased to 1.1%. If you look at matrix 2 in your notes, that will show you this particular phenomenon. What it also shows is that boys are disproportionately higher than girls among juveniles in conflict with the law. In 2015, the ratio of girls to boys who were apprehended for offences under the Indian Penal Code was 1 girl to 45 boys. This is shown in matrix 3. Matrix 3 also shows that unlike popular notion, the crimes committed by juveniles is not highest among rape. In 2015, the highest share of cases registered against juveniles were reported under the crime head of theft. This is 19.2% cases of theft, criminal trespass or burglary, which was 8.3%, rape, which was 5.4%, and kidnapping and abduction, which was 5.2%, and causing injuries under rash driving or road rage, which was 4.9%. So it's important for us to remember the highest incidence is not that of rape. These 5 crime heads together have accounted for 43% of total Indian Penal Code cases against juveniles, that is 31,396 cases of juveniles in conflict with the law. Now let us try and understand what is the need for a separate system of criminal justice for juveniles. Why should they have a separate system at all for justice? World history bears witness to the fact that children have been prosecuted and punished for commission of offences in adult courts and lodged in jails along with adults. It is only in the last century that slowly there is a consciousness that has arisen, leading to a separate justice process for juveniles. Despite the existence of the juvenile justice system in India, there is often no clear understanding among members of the public as to why the juveniles cannot be treated like adults, why they cannot be prosecuted in adult courts, why they cannot be punished like adults, and why they cannot be lodged in adult jails. Whenever a juvenile is accused of committing a heinous crime, there is a public outcry that the juvenile justice system is lenient, and there is a demand for exemplary and stringent punishment with deterrent effect as a way of providing justice to the victim. Such responses and demands arise from a very, very inaccurate and incorrect understanding of the juvenile justice system and the philosophy behind the same. Such moves and such demands have resulted in more punitive responses to juvenile offenders. There are many, many reasons and arguments that are advanced in favor of a separate criminal justice system for juveniles. Now let me try and explain a few of these. Number one, it is a fundamental principle in law that if unequals are brought on one platform and treated in the same manner, that would result in inequality, not equality. Children, we would all agree, are differently situated from adults. Secondly, children are one of the most vulnerable sections of the society, and they are also victims of exploitation and abuse by parents, by guardians, and by the larger society. Hence, what juveniles require is a humane approach, not a law and order approach, and definitely not a retributive approach to justice. Third reason, millions of children are left on the streets to fend for themselves. Many of these children are abused, they are forced to work, and they are forced to beg. They work in exploitative conditions, they are subjected to violence, and they are denied the right to a dignified life, which is the human right of all, including children. Such children are in dire need of care and protection from the state as well as from society. A major contributory factor to children coming in conflict with the law is the abuse, the exploitation, the neglect that is meted out by society to the concerned child. So, a manner in which the society can actually attempt to repair the harm that it has caused to the juvenile is by adopting a humane, rehabilitative and reparative approach to children. Fourth reason, putting children in jail along with adults is not going to help them reform or reintegrate with society, but it would instead cause them to become hardened criminals, which is definitely not something that we want. Fifth reason, children are often not aware of the consequences of the acts that they commit due to their tender age. Even when they commit heinous offences, they don't always understand the consequences. Hence, such acts, even though they may be punishable offences, these children need to be treated differently from adults because adults are presumed to know the consequences of the acts that they do. Now, in the notes, there are bullet points that provide a comparison of differences between the juvenile justice system and the criminal justice system that is applicable to adults in India, in the words of the Supreme Court in a very famous case of 2014, that is Subramaniam Swamy's case. Firstly, FIR and charge sheet in respect of juvenile offenders is filed only in serious cases, whereas where adult punishment exceeds 7 years. Secondly, a juvenile in conflict with the law is not arrested but is apprehended. So, there is a difference between these two terms, and only in case of allegations of a serious crime. Thirdly, once apprehended, the police must immediately place such juvenile under the care of a welfare officer. This welfare officer is provided for under the law, and the welfare officer's duty is to produce the juvenile before the Juvenile Justice Board. Thus, the police do not retain pre-trial custody over the juvenile. Fourthly, under no circumstances is the juvenile to be detained in a jail or in a police lockup, whether before, during or after the inquiry by the Juvenile Justice Board. Fifthly, Grant of bail to juveniles in conflict with the law is the rule, it is not the exception. Sixthly, the Juvenile Justice Board conducts a child-friendly inquiry, and it is not an adversarial trial which is fought between two warring parties. This is not to say that the nature of the inquiry is non-adversarial, because both the prosecution and the defense would submit before the Juvenile Justice Board their cases. However, the nature of the proceedings acquires a child-friendly color which doesn't exist in an adult court. The emphasis of criminal trials is to record a finding on the guilt or innocence of the accused. But in contrast, in the case of established guilt, the prime object of sentencing is to punish a guilty offender. In contrast, the emphasis of juvenile inquiry is to find the guilt or innocence of the juvenile and also to investigate the underlying social or familial causes of the alleged crime. Thus, in contrast with adult criminal system, the aim of juvenile sentencing is to reform and rehabilitate the errant juvenile. Further, the adult criminal system does not regulate the activities of the offender once he or she has served the sentence. However, within the juvenile justice system, because it seeks to reform and rehabilitate the juvenile, it establishes post-trial avenues for the juvenile to make an honest living. So that is the focus on reformation, on rehabilitation, on reintegration with the society. Now let us look at two varying approaches to juvenile justice which have influenced laws and policies over the past 2 centuries. One approach is the need-based or the welfare-oriented or the charity-based approach. Now this approach has influenced law and policy on juveniles for centuries. This approach perceived children in need of care and protection as tragic victims of circumstance who deserve the sympathy and pity of society. Charities gained importance as a means for the survival of such children. Since the charities were bestowing a benefit to the children out of their own benevolence and out of their sense of pity, they expected the children to be grateful to them and to abide by their conditions. Though some children did benefit from the welfare approach, by and large, we can today look at this phenomenon and we can say that such an approach was disempowering for children, as they had no say in what would be the benefit that was given to them. And they also had no say in the manner or the duration for which they were given the benefit. While the welfare approach was well intended, with a particular focus on the welfare of children, what it did not do was that it did not adequately focus on developing the children's potential to the maximum in order that they become capable human beings. The charity or the welfare approach was particularly problematic because it did not recognize the capacity of the children to participate in or to voice their opinion on crucial decisions that affected their lives. Further, it did not aim at promoting inclusion or mainstreaming of such children into society in the long run. Its approach led to segregation rather than integration of children in the mainstream society. While charitable organizations working on or caring for children play a supportive role, it is very, very important that persons who administer such charities acknowledge and promote the empowerment of children, warranting the society's respect for their rights rather than addressing the perceived needs of the children. However, with the formulation of international standards on child rights, particularly the United Nations Convention on the Rights of the Child, there was a paradigm shift from a welfare-oriented, charity-based approach to a rights-based approach. This approach perceived issues pertaining to the child as legally enforceable rights and entitlements with corresponding duties and responsibilities on the state, on the family, and on the community at large. The present Indian law, which has witnessed major amendments in 2000, thereafter in 2006, and then in 2015, is aligned with the rights-based approach to children and to juvenile justice. The evolution of international standards of juvenile justice are discussed in further detail in modules 3 and 4. The matrix 4, which is given in your notes, that gives the difference between a need-based and welfare-oriented approach and the rights-based approach to children. So, if you look at matrix 4, that will give you this difference in the approaches. Now, let us try and understand the very important issue of punishment versus rehabilitation. Punishment, which is often emphasized, versus rehabilitation for juveniles. There is no denial that young people sometimes commit heinous offences such as murder, rape, and so on. Though most juvenile offences may not result in grievous injury, sometimes it does. The moot question is, what is the best response to such heinous offences of juveniles? How are juveniles to be treated by the legal system in such a way that he or she learns from their mistakes and makes more socially productive and responsible decisions in future? Which response would amount to a sound investment of public funds? How should law balance the need for safety of the community with the need for each juvenile to develop to his or her potential? There are no easy answers to these questions. Every country has a trajectory of lawmaking and implementing processes that make a viable attempt to respond to such questions. However, the law and policy on juveniles ought to be shaped by the causative factors discussed just now, such as the root causes will be addressed through the law and not merely the manifestation of the same, which could be the offense that is committed by the juvenile. Punishment is not always an effective response to criminal offenses that are committed by juveniles. Sometimes punishment, incarceration, isolation from society, exposure to harassment, torture by state authorities in custodial situations, restrictions in human interactions, naming, shaming, labeling, and stigmatization can cause the juvenile to have further deviant behavior, which is totally not desired. This deviant behavior is also called secondary deviance. Even among adults, recent jurisprudence on theory and of punishment and criminology advocates a reformative as opposed to a retributive approach. among children and adolescents, it is important to adopt an approach that is aimed at rehabilitation, reformation, and reintegration into society as a productive member of the society. Juveniles need a humane treatment aimed at reformation rather than punishment. Let me quote a young boy in India who has gone through the juvenile justice system, who said this: "We learn everything from adults. From people who take drugs, we learn to take drugs. From people who make bombs, we learn to make bombs. And that is what we will learn when you send us to jail. So if you send us to jail, we will become like adults." Let us now try and understand the evolution of juvenile justice in India and look at how the law has developed. The historical development of juvenile justice in India can be divided into 6 phases through reference to the treatment of children, to the legislative developments, the judicial intervention, as well as other government policies. These 6 phases are: prior to 1773, 1773 to 1849, 1850 to 1919, 1919 to 1950, 1951 to 2000, and lastly 2001 to 2017. Let us look briefly at what happened in each stage. Prior to 1773, we had the Hindu law, which was Manusmriti, and Islamic law, which was Sharia. Both of these governed the society, and both of these emphasized on a proper upbringing of children as the sole responsibility of parents. They had to care for and protect the children, and if the families were unable to or incapable of doing that, then someone from the community had to take care of the children. According to Islamic law, if an abandoned child was found and it was felt that this child would be harmed, then the person who found the child was under a duty to take care of the child. If we look closely at Manusmriti and Sharia, we can see that children were prescribed different punishments for the commission of certain offences. For example, under Hindu law, if a child was found throwing filth in public, he had to clean the place, while an adult who did the same thing had to pay a fine. In Muslim law, there was a specific injunction which prevented execution of children. This was specifically for children, whereas for adults they could be executed. So we can see that children were treated separately and differently from adults, with a special focus on their care and survival. They were not fully held responsible for their actions as adults were. Let's look at the next phase, that is 1773 to 1849. This was a very important period in India. It was a period which was predominantly dominated by the East India Company. East India Company started as a trading company in 1608. After the company failed, the crown took over the reins through the Governor General. This was the period when the momentum in reform started gaining pace, and the effect was also visible. Colonial exploitation ruined the agrarian economy in India. This resulted in forcing the deprived classes to live in slums or in the outskirts of city. This increased destitution and delinquency among children. The year 1773 was a landmark year because that is when the Regulating Act of 1773 granted East India Company the power to make and to enforce laws for the first time. Further, the Charter Act of 1833 changed the commercial status of East India Company into a governing body. Between 1773 and 1850, many committees were established focusing particularly on children in jails. In this phase, welfare mechanism for children took different forms. For example, Krishna Chandra Ghoshal and Jai Narayan Ghoshal approached the then Governor General for establishing homes for destitute juveniles in the major trading city of Calcutta, which is now known as Kolkata. Similarly, the first ragged school for vagrant and orphan children was established in 1843 in Mumbai, which is now known as David Sassoon Industrial School. The objective was to reform child delinquents who were arrested and by encouraging them to work through apprenticeship and through industrial training. This prepared the base for passing of the Apprentices Act of 1850. The approach adopted was largely welfare oriented and need based. Let's look at the third phase, which is the status of juvenile justice from 1850 to 1919. In 1850, the Apprentices Act was passed. What this act did was basically to keep the juveniles out of jails, and subsequently, by the report of the All India Jail Committee of 1919 to 1920, children were segregated from the prevalent criminal justice system. This period saw the passing of specific legislations concerning children, the first of which was that it provided a special status to juveniles, that was through the Apprentices Act of 1850. Children who were vagrants and committed petty offences in the age group of 10 to 18 years were made to undergo their sentence as apprentices. The objective of the law was to channelize the energy of children and to divest their minds from criminal influence and to make them work so that after they reach the age of majority, they can earn a living and become a productive member of society. Subsequently, the Indian Penal Code 1860 fixed an age limitation for criminal culpability of juveniles under section 82 and 83 of the Indian Penal Code. The said sections provided protection to children from criminal prosecution until they had developed cognitive faculties to understand the nature of their actions, to understand the consequences of their action. The Code of Criminal Procedure in 1861 and 1898 in 3 sections, that is section 298, 399 and 562, prescribed for a separate trial for the persons below the age of 15 years and required that they should be confined in reformatories rather than in adult prisons. This changed the approach towards and the treatment of juveniles from punishment to reformation. As prison reports constantly pointed towards the change in policy and administration, noticing a high rate of perpetrators and an increase of juvenile offenders, especially in Pune, where the number alarmingly increased from 1 to 65 between 1860 and 1861. the Whipping Act of 1864 was passed by the government. This act was passed with the aim of deterring children from committing crimes in future by whipping them for certain crimes, which in consequence would save the government of the investment to establish reformatories for the juveniles. So in the remaining 3 phases, that is 1919 to 1950, 1951 to 2000 and 2001 to 2017. In all these 3 phases, there has been a lot of development on juvenile justice law. This is given in detail in your notes, so please refer to that for further detail. So let us now come to the conclusion. In conclusion, this particular module that we have discussed is the introductory module on juvenile justice system in India. This module is of course not exhaustive, but it is meant to only give you an overview and to introduce you to the topic. So please read the notes and look at the references for further details so that you will gain a better understanding of all the issues that have been discussed in this module. Thank you.